Okay, I think in the interest of time, we'll start today. As you know, this panel will be exploring comparative view and perspective of constitutional justice in some of the countries in Europe. So basically it will be Albania, Estonia, Poland, Romania, Lithuania, Kosovo, and Germany. So probably, I don't know, some of you maybe come from the Latin America, and that might be an interesting thing to see how the constitutional justice is evolving and its architecture is in some countries of Europe. As you see, some of the countries actually come from with a, let's say, inheritance of authoritarianism. So some of our countries have been under a communist regime, and basically constitutional changes happened after the Berlin Wall fell. So that might be an interesting perspective also to see. Although our countries share some similarities, probably the constitutional architecture is different, and that will be an interesting, I guess, discussion or exploration of constitutional justice to see that sharing the same inheritance, we still have differences in the way we see our, let's say, constitutional institutions be built and established. So I'll start a little bit with Albania, but before doing that, I'll tell you that the focus of our discussions will be mainly the individual complaints. So how our courts allow for individual complaints and in a certain way serve the concept, the very important concepts of being courts of citizens. So that will be the main view. However, if you need to explore any other thing regarding the jurisdiction of the constitutional courts or other aspects of constitutional review, for example, of acts, will be open, I guess, and I share, I think, the same perspective from all the panelists here. So you can ask questions also that are not covered by the discussions and the presentations today. So I'll start with a brief presentation of Albania, of Constitutional Court of Albania. The Constitutional Court has been existing only for 32 years. Before that, we didn't have a Constitutional Court because during the communism regime, it was not foreseen to have a Constitutional Court. After the fall of that regime, we had constitutional dispositions for some years, and only in '98 we had the first constitution after the fall of the regime. However, the Constitutional Court started with these little constitutional dispositions that were the preamble, the initiation of our Constitution. Based on the Constitution, it was given the right to individuals also to claim or to present constitutional complaints. And since the beginning, the question posed was the Constitutional Court a fourth-level constitution, a fourth-level court? And I guess this is a struggling question throughout the years that the Constitutional Court has been. I mean, sometimes it is also a tension between the Constitutional Court and the ordinary courts. And I don't know, and I'll be eager to hear from other jurisdictions and other countries, but this is one thing that we tend to try to delineate, although it is a very fine line sometimes. Just for your information, also, the European courts, the European constitutional courts, they are part of an organization that is called European Conference, the Conference of European Constitutional Courts. And the last conference was dedicated to deference, to the fact that how the constitutional courts withhold themselves without trying to go and take jurisdiction from the ordinary courts. Having said that, you know, I mean, most of you know, but will be able also to address questions. The same complaint that goes to the ordinary jurisdiction can come to the Constitutional Court of Albania only for questions regarding the human rights and the fair trial. Only if you have a claim regarding the fair trial, or due process, as it is called in the States, or the common law countries, only for these complaints you can come to constitutional courts. So to say that interpretation of the laws, the general interpretation of the laws still stays with the ordinary courts. However, if the process has failed to fulfill the standards of a fair trial, you can still come to constitutional court. Another question that has been presented to the Constitutional Court is the fact that if you find a problem regarding the process, do you have the final word on this? Do you have the final saying on the matter? Or should you readdress the case to the ordinary courts? And in Albania, based on our constitution, we can do both. Sometimes we can end and have a final saying on the matter, and sometimes if the deficiency of the wrongdoing is found regarding the fair trial or the due process, you have to return the case to be tried and have a final verdict by the ordinary jurisdiction or ordinary courts. Another thing that, as you might know, in Europe, there is also a supranational jurisdiction that is assigned to the European Court of Human Rights. That means that before a complaint is presented to the European Court of Human Rights, you have to exhaust all the legal remedies. And by saying that, it means that you have to exhaust also, the complaint should be also brought before the Constitutional Court, unless, for some reason, the complainant can justify that the Constitutional Court is not an effective remedy. There are no cases like that, but anyway, it exists as a principle. With the amendment, the last amendment in our Constitution that happened in 2016, the complaints could be presented also for substantive rights, substantial rights, not only for due process. This was a big development in constitutional justice. Why? Because with that, let's say, addition, the Constitutional Court jurisdiction was widened, and somehow we served as a pre-Strasbourg court. Why is that, and what were the problems that posed this change or this amendment? The change made it possible for individuals to present complaints not only related to the due process, meaning that due process, all the standards for fair trial were already respected, but they nevertheless could still present a complaint to the Constitutional Court asking that or complaining about the interpretation of the law that eroded or violated the constitutional rights. Why this thing was very important and also a new development? Because as I mentioned before, the interpretation of the law was a domain, it is a domain of ordinary courts. So to enter into that domain and verify the interpretation of the laws and making your own interpretation, so how the law should be interpreted in order to meet the standard of a right, was something new that the court has tried to develop after such changes in our constitution. And that posed also, again, the problem of how we will intervene with the courts. And sometimes just because of this new perspective, this new filter, if you might say, our court can rule and have a final verdict, not sending back the decision or sending back the case to be tried by the ordinary court. A new thing that happened also in 2016 is that an individual together with a normal complaint that goes throughout the ordinary jurisdiction, could claim the unconstitutionality of a law, of a normative act. What is the difference with other subjects or entities that can ask for such a constitutional review of acts? The difference here is that the citizen should state and should show that the law that he is asking that is unconstitutional should be applicable to its case. It cannot come like we have that, one subject that is unrestricted subject is 1/5 of the MPs, of members of parliament that can ask for a constitutional review of normative acts. But also the citizen. But the citizen should show that this law is applicable. And basically, if the law is applicable as such, the result of the case will be unconstitutional, and that unconstitutionality comes only because of the law itself, not from the law as it is applied or interpreted by the ordinary courts. And this was also something new that we have seen it. We have now an extensive jurisprudence on this perspective. And we've had some very good cases, mostly related to property rights and some laws related to wages and some laws regarding the liberty, the right to liberty. So this is in a nutshell, basically the jurisdiction of our court regarding individual complaint. I know that we can go on, but I thought maybe to keep a narrow, let's say, discussion on this subject matter, and then probably we can explore other subjects of interest that you'd be interested of the audience. So I'll not go longer because I want to give the floor to the next panelist, which is Villu Köwe from Estonia, that will elaborate basically almost the same theme. Thank you, Villu.
Thank you, Madam Chair. As you told, our topic is the individual constitutional complaint, and as we don't have it in Estonia, I had to cancel it, my presentation right now, but I don't make it so easy. And I give some brief overview over our system and how our Supreme Court is working and what we are doing in what group of cases. We are exception here, I think, yeah. All the countries here have the separate constitutional courts, yeah. But we don't have it in Estonia. Most countries in Europe have Estonia, we haven't it. According to our constitution, the Supreme Court also serves as the Court of Constitutional Review. We have merged the powers of two courts, and that we don't have any other separate highest court as administrative highest court too. We have all together merged in the Supreme Court. We are a very small country, only 1.3 million people. We said that this. We don't need so many Supreme Courts, highest courts. That's what our people say. In the Supreme Court, there is a special constitutional review chamber, which is chaired ex officio by the Chief Justice, and other members of the chamber are elected by the Supreme Court. All the judges are appointed for the lifelong, but they serve as the members of the constitutional review for 4 years. In the most fundamental questions, the case might be referred to the Supreme Court en banc. Consequently, it can be said that all the justices of Supreme Court also serve as constitutional justices. The applications may be submitted to the Supreme Court by the courts, the President of the Republic, Chancellor of Justice, and local government councils. Individuals may approach the Supreme Court regarding constitutional review only in very few cases. And the most important case are the elections complaints. Supreme Court has recognized the individual's possibility to directly address the Supreme Court if the person has no other effective remedy to protect their rights. Only then. But this is not prescribed in the law, this is the case law of our Supreme Court. And in fact, in practice, there has been only one individual in 30 years. The Supreme Court told that you have no other remedies, please come to us. Okay, the protection of individuals against the violation of rights and freedoms stipulated by general legal acts in Estonia is organized through a norm control model, and all the courts of all instances, they have the right and they have the duty to control the constitutionality of the legal acts they are applicating. And they may refer to the Supreme Court to declare the law unconstitutional. They don't have the right for the preliminary ruling on the constitutionality. That means that the law instance court must decide upon the case, and by doing so, not apply the unconstitutional provision. Non-application does not render the relevant provision invalid. Only the legal consequence of the norm is not applied. The competence for the binding determination of unconstitutionality lies only with the Supreme Court. And with evaluating the relevance criteria, the Supreme Court is not bound by the arguments of the court that submitted the application. If the request for norm control is justified, the Supreme Court shall declare the legislative act or part of it unconstitutional and invalid. Just a few words about such institution like the Chancellor of Justice, that somehow maybe is addition to the system and replaces somehow this individual complaint. As this Chancellor of Justice has such unique, maybe, constitutional institution that is independent and does not belong to the legislature, judiciary, and executive branches, and this Chancellor is tasked with reviewing the legislation of the legislative and executive powers as well as municipalities for conformity with the Constitution and laws. And according to the law, everyone has the right to recourse to the Chancellor of Justice to review the conformity of a law on other acts. And Chancellor can bring the question of constitutionality of any law before the Supreme Court. That means it somehow replaces the individual complaint. We can say. So what the Supreme Court has done and how it's working with these powers that we have, that our legislators have given the Supreme Court, we can say the Supreme Court has worked as protector of democracy, rule of law, and basic rights of the people. And some words about the most important maybe cases or types of cases we are dealt with. And then the first one is the maybe safeguarding the sovereignty of the state. The Supreme Court has the important role in the protection of the state, let's say, and then especially in the cases when the question is of the supremacy of EU law and the national constitution is one of the main and very important task, and Supreme Court has dealt with it twice in the last 20 years, and then told to the law instance courts how the control of the norms should be and how long we can go with the European law. Second group of cases, especially in recent years, we had several cases initiated by the minority of the parliament who tried to obstruct the work of the parliament and about the countermeasures against them. As the hundreds of the questions of the minority were not answered, the amendments proposals ignored, or the laws passed in the speeded proceedings with linking the draft with the trust to the government. That was the one point and then task of our court to look the balance in the work of the parliament. This is very important, we will say. And the next one are the election complaints, that it's very important that our parliament and local governments had legitimation, and then Supreme Court will look all the complete constitution, all the electoral complaints. Our special case is that Estonia has been conducting electronic elections already for 10 years. And we have many very technical, let's say, complaints about the voting system. Then we had, in the last years, especially some very important cases about the autonomy of the local government units. That means that we have now, at the moment, we have 2 cases pending. One is about dividing the money, let's say, between the state and local governments. It's come from income tax. And the second is about the planning financing duties of the local governments. But the people complaints that are coming from through the lowest courts are very important too, of course, and especially in the last years there are many cases related to the social rights of the people, demand supports. We had very big case about the pension reform of Estonia, and now some cases are pending about the fair and equal treatment in the regulation on different social support measures. Supreme Court has, let's say, we had some very strict decisions, very important cases safeguarding the rights of individual involving in disproportionate financial burdens. Supreme Court declared unconstitutional court fees and court bailiffs fees as they were unproportionally high that we have invented there. And in some cases, Supreme Court reviewed the constitutionality of the criminal penalties, even to their severeness. And it's very important that the legislator tries sometimes to restrict the people's right to go to the court, and then these restrictions were all declared unconstitutional. And then lastly, we had some important cases against the privatization of the state power, let's say, the power to exercise punitive functions or the legislative functions. That's the brief overview of our system. Thank you very much.
Well, thank you. I think I'll pass the floor to Miroslav, Granat, Poland. So let's try to speak about the subjects, maybe, and just with a focus on individual complaints.
It's functioning. Okay. Thank you, Mr. Muchas gracias, and my progress in Spanish is follow. My task is extremely difficult, and I think that this is impossible to say now about the individual complaint and individual access to the Constitutional Court in Poland, because, you know, I'm sure exactly that Polish Constitutional Court was destroyed by politicians, by the political parties. So Tribunal lost his credibility. This is the precious feature of the Constitutional Court for all judges, etc. And Tribunal was destroyed. This is the deadlock of the Tribunal. And sorry, but I would like to title my remark concerning how to reinstate Constitutional Court in Poland for accessing to the individual constitutional complaint or other means of the court. Sorry, but firstly, a few phrases concerning the history of our tribunal, because this is as a phenomenon. So the Constitutional Court was established in Poland in 80s, in the period of the so-called real socialism. And what is important for my task here, that the communist government ensured the weak position of the tribunal. In this light, what seems astonishing is the evolution of the tribunal from a weak control body to an independent constitutional court. I say to the students at the university that it is an illustration of the well-known story of the adventures of Baron Milhausen, who got himself out of the abyss by pulling himself by his own hair. In the 90s, after the collapsing of the communism, tribunal gained competences typical of a court falling into Kelsen's model. Kelsens seemed to be a patron of judicial review in Poland. That is, the tribunal guarded the supremacy of the constitution in the system of law. But I remember that in the 90s and 2000s, the tribunal was treated with great respect and admiration among politicians, among the people. This body not only performed the function of guarding the purity of law, as in Kelsen's model, but it also led us towards Europe, protected human rights, and acted as a mentor for law-making process. But the prices, a specific price paid for the high position of the independent constitutional court in the system of law and in public life, was the populist attack of this institution. The populist attack was a reaction of politicians to a strong position of an independent court. Such court was not needed. Here I want to skip the question of the process of the destruction of the tribunal. I would like to add only one information that I divided between 3 stages during the process of destruction. Firstly, this was takeover of the Constitutional Tribunal 2015-16, thanks to understudy judges, or next to remedy laws, in inverted commas. Remedy laws, this was a series of ordinary laws concerning the tribunal, adopted by the same every 2 or 3 months. Second step, this was the loss of authority, 17-2020, and this was a blackboard campaign against justices, intimidation, profane form, threats, etc. And next, final etap after 2020, tribunal was subordinated to politics. For example, there are the judgments concerning the disputes over authority, next judgment direct against the ECJ of the EU, etc., etc. So I can finish this part of my remarks that after 2022-2023, tribunal was incapacitated, in fact self-incapacitated, but was necessary for the politician, for the ruling majority at that time. And I have many proof here concerning this, my note. So the measures described above illustrate a successful scheme of dismantling a well-functioning constitutional court, which should be included in law textbooks of illiberal constitutionalism. So the core of my presentation, the core of my paper concerning can we reinstate constitutional review and open the review for the people. So firstly, this is the question, the significance of the lesson learned from 8 years of illiberal constitutionalism in Poland 2015-2023, when politicians attack a single central constitutional court. It seems to me that the most important lesson is the need to break away from identifying the constitutional review exclusively with the tribunal in favor of appreciating the review exercised by judges of common and administrative courts. This kind of review should be as a bridgehead for a revision of the centralized model. Many of us treat dispersed review in Poland as an emergency measure and not as a solution coexisting with the Constitutional Tribunal's monopoly on ruling on the constitutionality of law. The Constitutional Court may rule on the constitutionality of law in dialogue with other courts. In order to maintain the position of the tribunal, it seems unnecessary to preserve its monopoly, in inverted commas, on review. Monopoly can be interpreted as a state in which the Constitutional Tribunal dominates, making the position of an arbitrator. Centralization of review does not necessitate a monopoly of the tribunal and does not have to mean its domineering position. Next, Kelsen's model of constitutional judiciary must take into account the significance of dispersed review. I am well aware that Kelsen compared centralized review in the Austrian model, with the centralized review, judicial review in the American model. He came to the conclusion that the latter model is dangerous for the system of law. But why didn't Kelsen consider that in certain situation a monopoly of review by a single central court may become impossible? After all, he knew the events from Austria in the 20th century, when constitutional amendments were introduced, which soon led to the dissolution of the entire Austrian court. I think that Kelsen, having undergone the experiences of 1929, would not be surprised by what happened to the Polish Constitutional Court, Hungarian Constitutional Court, Turkey, Slovakia, and maybe other. So according to me, obviously, if the Kelsenian Constitutional Court is to survive in Poland, we must take into account the changes which have occurred in constitutional law, including those that have taken place under the influence of illiberal constitutionalism after 2015. I think about the development of dispersed review performed by independent judges from common court and administrative court. So, next, another difficulty with revising Kelsen's model lies in the fact that repairing of the tribunal in Poland is not merely a technical operation. Today we discuss about it with the panel with Minister Mazur. So, according to me, this is very vital, that the fact that repairing the Constitutional Tribunal in Poland is not merely a technical operation, but must be carried out on a living body of the state ruled by law. This is a well-known dilemma. Can we violate some principles of a democratic state ruled by law in order to restore the rule of law? So last phrase, okay? It seems to me that in Poland we should not be concerned with restoring the monopoly of the tribunal. We should work towards a model of compromise between centralized and dispersed review.
Well, thank you. Well, let's try to keep on the time so that we leave more time to questions, but it was very important, I guess, because the Poland situation is a very unique one, and probably we need to know a little bit more and basically address also the challenges that state ahead in your country. So anyway, thank you for your presentation. I will pass the floor to Gheorghe from Romania. And let's try to focus on probably just the subjects that can initiate the constitutional complaint with a focus on the individual complaint. Thank you.
Thank you too. I'm glad for the opportunity to address you in a context of the prestigious World Law Congress organized by the World Law Foundation, which for the 60 years has been bringing together judges, lawyers, professors from around the world to debate issues of interest to the legal world and the general public. The topic that I would like to present to you is addressing legislative omission through constitutional review, an issue that I consider to be of great topical relevance. Constitutional justice, a cornerstone of modern democratic states, is embedded in the institution of constitutional courts, which are entrusted with the crucial responsibility of safeguarding the supremacy of the Constitution and ensuring that all legal norms are in line with its dictates. These courts play a pivotal role in upholding the rule of law, protecting fundamental rights, and fortifying the foundations of democracy by exercising judicial review over legislative and executive actions. Among the multifaceted challenges that constitutional courts encounter, the issue of legislative omission stands out as a particularly complex and contentious area of constitutional review, where courts are called upon to assess the constitutional implication of what the legislator has failed to enact. Legislative omission, in its essence, refers to the failure of the legislator to address a matter that is deemed necessary or constitutionally mandated, thereby creating a void in the legal framework that may impinge upon constitutional principles or individual rights. In addressing such omissions, constitutional courts navigate a delicate balance between respecting the separation of powers and ensuring the effective realization of constitutional values. Constitutional courts must develop a coherent set of constitutional values emanating from a Bill of Rights to guide their decisions, while also recognizing their role as protectors of the Constitution. The scrutiny of legislative procedures is important, and judicial review, tempered with self-restraint, foster respect for legislation and reinforce the separations of powers. A comparative analysis of the case law of constitutional courts within the European Union reveals a diverse range of approaches to the issue of legislative omission. Some courts have adopted a more differential approach, emphasizing the principle of separation of powers and the democratic legitimacy of the legislator. These courts are typically reluctant to issuing orders that directly compel the legislator to enact specific legislation, preferring instead to issue declaratory judgments that highlight the constitutional deficiency and invite the legislator to take corrective action. Other courts have taken a more interventionist approach, asserting their authority to issue orders that mandate specific legislative action in cases of gross constitutional violations. As regards the Constitutional Court of Romania, as stated in Article 2, Paragraph 3 of law, which governs the Constitutional Court, the court's authority is limited to assessing the constitutionality of submitted acts without the ability to modify or add to the provisions under review. Acting strictly as a negative legislator, the courts cannot create new legal standards, even in a supplementary capacity, nor can it alter existing regulations. It is only empowered to determine if a primary regulatory norm conflicts with the fundamental law. When such a conflict is identified, the court declares the norm unconstitutional and, by extension, inapplicable. This limitation is due to the fact that so-called legislative omissions primarily relate to issues of expediency rather than legality. The Constitutional Court's role is restricted to verifying compliance of laws with the Constitution, not assessing the appropriateness of legislation. Any deviation from this approach would lead to court to overstep its jurisdiction, representing an unacceptable interference with legislative authority. Conversely, not all legislative omissions stem from lawmakers evaluating the suitability of regulations which involve a degree of discretion and judgment. Consequently, the Constitutional Court has not consistently dismissed objections targeting this alleged omission of criticized legal provision and inadmissible. In instances where such legislative omissions directly led to evident violation of constitutional rules, the court addressed them by accepting the exceptions of unconstitutionality raised. One decision dated 2017 identified a substantial flaw in the interpretation and enforcement of two rules concerning the case involving the constitutional exception. This flaw stems from the failure to establish a clear definition of agricultural or forestry tractors within the context of the offense described in Article 335 of the Criminal Code, which addresses the operation of a vehicle on public roads without a driving license. The court determined that this issue is not merely an intentional legislative choice, as indicated by the provision of Article 73 of the Constitution. Rather, it represents a significant legislative gap with constitutional implications. This gap grants the Constitutional Court the authority to rectify the situation through a review of constitutionality. According to its established case law, the unconstitutionality issue raised cannot be overlooked even when it arises from a legislative omission, since such omissions and ambiguities may violate constitutional rules. In another decision dated 2017, the court concluded that the lack of the specific provision in Article 58 of the law which governs judges and prosecutors' statutes creates legal uncertainty by failing to specify the conditions for early termination of secondment. This unpredictability violates Article 1, Paragraph 5 of the Constitution. Given this legislative void, the court ruled that the existing legislative approach conflicts with sound legislative principles, as it could have been clarified through a normative act issued under the law, namely a decision of the plenum of the Superior Council of the Magistracy. In another decision from 2017 concerning the criminal aspects of the offense of abuse of office, the court determined that the lack of specific circumstances regarding the assessment of damage or the severity of harm to the rights or legitimate interests of individuals or entities complies. Excuse me?
Yeah, let's just try to wrap it up so that we're running out of time.
It's too much. Okay.
Thank you. Don't just wrap it up. You can make a final conclusion, but let's try to. No, it's very interesting, but.
In conclusion, the constitutional reviews of legislative omissions is a complex and multi-faced issue with no easy answers. First, it is essential to recognize that legislative omission can have just as significant an impact on constitutional rights as legislative actions. Constitutional courts should be willing to scrutinize legislative omissions to ensure that they do not result in violation of fundamental rights or undermine the effective implementation of the Constitution. Second, constitutional courts should adopt a framework that balances the need to protect constitutional rights with the principles of separation of powers and democratic legitimacy. This requires careful consideration of the nature of the constitutional right at stake, the extent of the legislative omission, and the potential impact of judicial intervention of the legislative process. Third, constitutional courts should be mindful of the institutional context in which they operate. This includes considering the political dynamics within the legislature, the capacity of the executive branch to implement judicial orders, and the broader social and economic context in which the case arises. Okay, thank you.
Thank you.
For your attention.
Thank you. We'll pass the floor to Jolita Miliuvienė from Lithuania. Did I pronounce it correct? You can say it yourself.
No, it was just fine.
Okay.
And thank you very much. It's a pleasure to be here among such honorable panelists. Although the topic that the Madam Chair invoked is very interesting, just like my colleagues, I will speak in a little more general manner about the protection of fundamental rights. But in fact, the first purpose of the individual constitutional complaint and the introduction of it was to create the more possibilities for individuals to protect their rights. Therefore, my topic about the role of the constitutional courts acting in the changing times, in backsliding democracies in a lot of countries in the European region is linked very closely to what Madam President told. Just for the introduction, a few remarks to say that although our countries all are different, maybe except Estonia, we all share the same Keynesian model of constitutional review. Lithuanian Constitutional Court, just like Albanian, if I understood correctly, counts 32 years. It was established after Lithuania regained the independence and adopted the new constitution. And we didn't have the individual constitutional complaint at the beginning because the state and the politicians wanted to see, first of all, how the constitutional court operates, because we never had such an institution of constitutional control. After 30 years, more than 30 years, the constitutional court gained the authority and the recognition among the society and among the state power institutions. Therefore, in 2018, we amended the constitution to introduce the individual constitutional complaint. To address the Constitutional Court, individuals was told to respect some conditions, and we had a lot of the same discussions that Madam President said in her introductory remarks, including the delimitation of the competence of the Constitutional Court and ordinary courts, the questioning whether the Constitutional Court became the fourth instance for protecting the individual fundamental rights, or whether it is even an effective measure, because after introducing the individual constitutional court, the hopes were very high that the individuals were be given the possibility to challenge the laws adopted by the politicians before the court. But in reality, we saw that the very low percentage of the individual constitutional complaints are accepted. Nevertheless, we had some practice some jurisprudence already formulated while resolving individual cases, but with or without the constitutional the individual constitutional complaint, the mere meaning of the Constitutional Court is to protect individual rights, to protect fundamental rights, and how the court does that. It is very important when we speak about preserving democracy, preserving the rule of law, preserving the same fundamental rights. And the constitutional courts can take different approaches when reviewing constitutionality of laws. And in difficult times, when all the values that we are used to live with are challenged, a strong and independent constitutional court can serve as the last bastion against the threat of constitutionalism. Sometimes, of course, the different approach, the judicial restraint might be more appropriate to have the same result, the constitutional values protected. And namely, the way the courts choose to deal with the cases might be the determinant factor for the success of creating a resilient democracy. And when the things go down in the state, and we witnessed a few examples in the European region, those wishing to preserve democracy would like to rely on the strong, independent, and active court, telling the state authorities what's right and what's wrong. The court that is not afraid of interpreting the constitution broadly, especially if the issue is linked to the fundamental rights, even potentially going beyond the explicit meaning of the text and original intent of the drafters of the constitution, but only in order to address perceived injustices and to adapt the constitution to contemporary values. That's why the constitutional courts, especially the active ones, are the first to become the target of antidemocratic forces, which happened in Poland, what Professor Granat talked about. But even in countries where there are no democratic threats and no democratic crisis as such, in the countries that are considered as the liberal democracies, there are still plenty of threats. One of the panels this morning spoke about the populism, but also there is the anti-EU rhetoric and the narratives of Rotten West, especially when with these ideas of gender ideology. And because of this, because of those threats, even in the countries that do not live the democratic backsliding, the constitutional courts always need to be vigilant and cautious, making thus sure that the rule of law is respected. And it is a duty and responsibility, as it was stressed in the opening ceremony yesterday. To do this effectively, constitutional courts themselves must deeply respect and constantly follow the principle of the rule of law. And sadly, we have some experience that some constitutional courts misuse the same principle to justify the decisions that go against fundamental universal values. And we don't have to look far for examples. Again, the Polish Constitutional Court decided that the Poland won't apply some provisions of the Convention of Human Rights, even the Polish state has committed to respect them, justifying this decision relying on the rule of law and saying that our constitution has the supremacy, therefore we won't respect the international obligations. Concerning the interim measures, the government explained that we can't force the judges to follow international obligations if they want to apply our constitution. So again, using the principle of the rule of law, wrongly using it to achieve their result. Another example is the Constitutional Court in Bulgaria, who abused the concept of the rule of law to argue that the Istanbul Convention for combating the violence against women, is incompatible with their constitution. The Bulgarian court misinterpreted the convention, giving to it completely different meaning that it was intended to, and misleading the public about the true purpose. In this kind of ruling, the Bulgarian court created the law that disregards human rights, denies human dignity, and paves the way for their violation. The Constitutional Court created the law that should not rule. Lithuania and the Baltic states in general usually are considered as the country where the democracy is not in the immediate danger. However, worrying trends of the European region do have an impact here too. We also have far-right voices, and because of the unstable geopolitical situation, we can't ignore those who openly or in more subtle way spread the Kremlin narratives. The last election in Lithuania showed that those narratives and those ideas found a place in the heart of the quite big part of the society, because the party whose leader was impeached and recognized that he has grossly violated the constitution was elected to the parliament again. His party won the 3rd place, and he is even the partner in the coalition. And this situation, by the way, highlighted another important issue, that the constitutional courts are facing the decline in their authority and respect. Because even the Constitutional Court of Lithuania ruled that that politician has severely violated the constitution. In the eyes of many people, namely the politician and not the Constitutional Court was right. But the courts are not for the populists. They cannot be populists, and they just can't say what the society wants to hear or is used to hear. And in this context, the Lithuanian Constitutional Court had to deal with 2 very sensitive issues related to individual rights, to the right of private life and right to create a family. The issues that everybody in the society has a thing to say. And the court issued two very important rulings, one on the reproductive rights of the woman and another on the partnership. In the second of those rulings, the court developed the constitutional conception of the family, saying that the family can be found not only on the basis of marriage, but also can have the other forms. Those other forms should benefit of a clear legal recognition and protection, and what is the most important, should be applied to the same-sex couples as well. What is interesting that the court has received the petition from the government, but also the individual constitutional complaint asking to protect those rights. And yes, very quickly. And it was quite new in Lithuania because Lithuania is a conservative society. And the Constitutional Court was accused very quickly of the activism, of stepping out of the limits, of saying the things that are not written in the Constitution. But a court that repairs the mistake of the legislator is not an activist court. It's a simply active court, properly fulfilling its mission, safeguarding the supremacy of the Constitution and the rule of law. A court that defends the rights of individuals or the minorities is not an activist court. It's simply an active court because it prevents the denial of fundamental democratic values and the degradation of human dignity. And the legal forums, the world forums recently were talking a lot about digitalization of law, about EA and the risks they are posing. However, it seems that we should not forget the fundamental values and basic principles, or consider them evident. Constitutional courts constantly have to return to the core values such as equality, the protection of dignity, and the rule of law, and consistently defend them, reminding everyone that these must come first. Thank you.
Thank you. Well, I'll pass the floor to Professor Visar Morina from Kosovo. So probably, since we'll have 2 representatives from Kosovo, we'll speak about individual complaints, and then the Jews will speak about probably the case law of European Court of Human Rights, international obligation. Okay, cool.
Thanks. Greetings to all. I know we have time constraints, so I'll try to be brief, rather brief. In fact, the theme is quite topical, speaking about the constitutional complaint in Kosovo sort of serves the purpose of this session today in order to have a view of a very unique model, actually, of not only with respect to constitutional complaint, but with respect to constitutional justice as well, because the constitutional architecture of Kosovo is quite unique. We have 1 constitution, 2 constitutional courts, so to say, one operating in Kosovo, located, broad jurisdiction, typical German version, I would put it that way, with abstract and concrete norm control. The other one is related to the specialist chambers of Kosovo. It is a very unique special case that deals with complaints within that particular body seated in The Hague, sort of rendering decisions on the basis of Kosovo laws, but it has a rather unique position. So by contrast to Estonia, for instance, there are cases where a country has 2 sort of constitutional courts, and this is quite, I think, unique, I would say, when it comes to comparative constitutional justice. With respect to constitutional complaint, in fact, there are certain, I would say, obvious features and characteristics that we find it in other countries as well. When it comes to ratio persona, for instance, the time frame within which that complaint can be used is a typical subsidiary instrument. And what is indeed peculiar when it comes to Kosovo is that Kosovo currently has no access to the European Court of Human Rights. It is not a member of the Council of Europe. It has not ratified the ECHR. The Constitutional Court acts, I would say, both as a local or national constitutional court in one hand and as a supranational court on the other hand, so to say, because once a final decision is reached by the court, it is final, and that cannot be appealed before the European Court of Human Rights, which is, in my opinion, quite problematic, where nearly 2 million citizens have no access to one of the most important judicial avenue in Europe. When it comes to the actual referral, it definitely constitutes one of the most frequent instruments, so to say, by citizens and legal persons. The case law is sound, is rich. We've had a number of interesting cases, which in fact, and I will go to this point now, have, with the passing of the years, the system has revealed, I would say, certain shortcomings of this instrument. And one of them is that our system of constitutional complaint lacks the so-called possibility for the court to accord damages for constitutional violation. It's not a recent case, in fact. There was a murder case related to domestic violence of the Castrati case, as we know it in 2010. The family, the parents of a killed woman, actually then filed a constitutional complaint before the Constitutional Court, accusing the competent authorities, basically, for having failed to effectively implement a protective judicial order, so to say, in order to prevent the death from happening, in fact. And the Constitutional Court was quite sort of direct in this sense. The court ruled that indeed that omission was unconstitutional, and the Constitutional Court declared a violation of the right to life and in fact the right to life in connection also with Article 2 of the ECHR. The problem, though, is that from a substantive point of view, that judgment, albeit its importance, had only I would say, only a declaratory effect. That was not sufficient for the victims, for the family. It is fine to have a judgment in the hands which states basically that, yes, there was an omission. That omission on part of the state was unconstitutional. So what's next? The family of the deceased woman, they had to institute new proceedings from the beginning, like civil law proceedings, in order to seek compensation for the harm and for the suffering, huge suffering that they have endured by the death of their child, girl, in fact. So, and that process lasted about 10 years until they finally got another judgment in hand by a local court. Having this in mind, I think it has sent a clear signal that maybe the time has come to sort of elevate and optimize this appeal or this remedy further by making certain changes in the law on constitutional court in Kosovo, which would then allow the court to follow the example of, be it the European Court of Human Rights, which is entitled to issue or to give just satisfaction, but also to follow, although it's not yet a rule in the European constitutional landscape, but there are certain countries like Croatia, for instance, Montenegro, outside of Europe, Canada, for example, they have already the possibility actually for the parties to seek material compensation for the constitutional damage that has been caused or that was caused by public authorities. And in fact, this would have, in my opinion, as I have elaborated in more detail in one of my latest articles in Vienna Journal on International Constitutional Law, that would certainly will have a lot of advantages, among which, or key among which, would be that it would serve as an incentive actually to public authorities in order to be aware that failing to undertake a task or interfering unconstitutionally will have consequences, not only declaratory, but financially as well. And that would, in my opinion, that would again strengthen and optimize further the real impact of a rather, I think it's one of the most important remedies in Kosovo's legal landscape as far as the effective constitutional protection of fundamental rights is concerned in the Kosovo context. Maybe there will be questions after the session, but just a short sort of insight of this ICC, I would call it, individual constitutional complaint in the Kosovo context. Thanks.
Thank you, Professor Visser. I'll pass the floor to Professor Jörn Axel Kämmerer from Germany.
Yes. Thank you very much. Good afternoon. Muy buenas tardes. Me siento muy honrado estar en este panel, but the presentation will be in English, and it will be about, well, not about Germany exclusively, but I've been asked to take a comparative glance at the functions of constitutional courts that are not represented here, although I'm not a representative of our constitutional court. There's a bit of a challenge considering the time, of course, but I'll try to face it. And in doing so, I'll focus on the constitutional courts of EU member states and on constitutional complaints. The constitutions of the member states and the founding treaties of the EU are a little bit intertwined vertically and horizontally to an extent that many scholars see them like constitutional compound or Verfassungsverbund, as we say in German. And along with it comes a compound of interacting constitutional courts, Verfassungsgerichtsverbund, that also encompasses as constitutional courts in a broader sense, and at least I believe they're constitutional courts in this sense. The European Court of Human Rights, our President mentioned it already as a very important in the constitutional realm, and the Court of Justice of the European Union, the ECJ. In terms of constitutional redress, we can observe that both levels mutually supplement each other. By the way, the redress to the European Court of Human Rights usually requires the exhaustion of national remedies, and this usually includes constitutional complaints where they're available and admissible. Not all member states, we've heard it, have a specialized constitutional court. Sweden, Greece, Estonia, Finland, Netherlands, or Ireland do not, but not having a constitutional court does not mean, I think this has become clear, that there is no constitutional redress. There is at least something that might feel being a gap, but if there is a gap, it's partially filled by the complaint to the European Court of Human Rights that can be filed against the acts, including laws of, at least de facto, of its 46 member states, and also by the Court of Justice of the European Union. To a lesser extent, however, individuals can bring a direct action for annulment against acts, and this includes laws of the European Union, but no such remedy exists against acts of member states that are not in conformity with EU law. An individual must rely on a national court submitting that question to the European Court of Justice. However, the ECJ has always refused to perceive the preliminary ruling as an instrument of individual redress. The Federal Constitutional Court has made it an individual legal redress, but this goes too far at this point. The presence of European Court and respective remedies has had a notable influence on judicial protection by national constitutional courts, not so much on the spectrum of available remedies, but on their scope. For example, some states have assigned constitutional status to the European Convention of Human Rights, in which case the court, the National Constitutional Court, also adjudicates on the rights granted by the Convention. In the Netherlands, the Convention even prevails over the Constitution, but the Netherlands have no constitutional court. Where countries do, such as Germany, the gradual shift of powers to the Union has the potential to weaken the constitutional complaint because it cannot be filed against acts of the Union or acts of Union origin, and the action for annulment before the ECJ is no equivalent for that. The Federal Constitutional Court attempted to mitigate these effects by declaring a judgment delivered in 2020, the Austrian Constitutional Court did so already 8 years before, that in some circumstances constitutional complaints can be lodged for violation of fundamental rights of the Union. The interplay of all this is very tricky and complex. I cannot elaborate on it here. There are quite a few legal systems with the Constitutional Court that do not allow for constitutional complaints. Here, the judiciary, the ordinary courts, are something like a gatekeeper in a similar manner as the EU does in the context of preliminary ruling. For example, Italy, where we have incidental constitutional control, Portugal, where the ombudsman can act upon the request of a citizen. France is a little bit closer to constitutional control, because in 2010, by means of constitutional amendment, a new legal redress known as question prioritaire de constitutionnalité was introduced, and the court must submit a statute to the Conseil constitutionnel, which is more or less the constitutional court, for scrutiny, even proceedings before that court, a party establishes that it violates the rights and liberties granted by the French Constitution. The party is thus endowed with a right to constitutional scrutiny, but the redress is an indirect one. Some other states provide a direct constitutional complaint, but is hardly anywhere fully fledged. Well, probably only in Germany, where it can be filed as an extraordinary and subsidiary relief against laws, against judicial decisions of all sorts, against acts of administration, and by everyone asserting the violation of constitutional rights. Maybe a little bit similar is the Spanish recurso de amparo, but it cannot be lodged against laws adopted by the central parliament, only against regional laws for all I know. In Austria, the Constitutional Court is competent for various individual constitutional redresses, which add up to something akin to the German constitution complaints. And it goes even a little bit farther because the European Convention of Human Rights is the same level as the Constitution. While laws can be overturned by the Constitutional Court upon the request of individuals, court decisions can't in Austria, except for judgments rendered by lower administrative courts. Countries that allow lodging a constitutional complaint against a statute, but not court or administrative decisions are, for instance, Poland, Belgium, where we have action for annulment, or Latvia. But the difference is only a faint difference because we have a level playing field because where courts, constitutional courts are barred from assessing administrative decisions, it goes through the law and vice versa. So we have always an indirect control of the other side as well. Besides Spain, the Czech Republic is one of the member states, for I know, where the court where complaints are also only admissible in judgments and administrative decisions, but not laws. Just a few words at the very end on the function of individual complaints. Virtually everywhere, the function is, well, at least in Germany, the function is dual one. It is for assuring compliance with the Constitution, constitutionality in the objective sense, and making the securing the respect of individual rights. And well, of course, everywhere where they exist, they're conceived as instruments of defense of individuals against the alleged violations of constitutional rights. There's just one exemption, which I just want to mention briefly, popular action, which we have under the Constitution of Bavaria. Everyone can bring a law before the Bavarian Constitutional Court. Another peculiarity of Germany, we have regional constitutional courts because he or she finds it is unconstitutional. The respect of objective constitutional provisions usually cannot be invoked in a constitutional complaint, but the German Constitutional Court, two sentences, has accepted the right to vote, for example, as an entry ticket to constitutional complaints on ultra-various acts of the Union. But this is confined to acts of the Union. It's an active constitutional court. And there is an increasing tendency in the jurisprudence to merge principles such as the rule of law, welfare state, with the most non-specific right, the general freedom of action. This is due because this is an aging constitution where data protection, the right to fair judicial procedure, right to habilitation are not enshrined, at least not in the wording, but it does not objectivize the individual constitutional complaint.
Well, thank you. And I'll pass the floor to Luz Balai. Can you try to be brief, since we had an overview on the individual complaints, so just the peculiarity of that, of the Constitutional Court from the international point of view?
All right, thank you. So, first of all, I've been listening today a lot of panels, and a lot of colleagues mentioned that it's the first Congress that we are missing Professor Reiner. So I wanted, since I'm coming here on behalf of the President of Kosovo, I wanted to publicly announce that with the proposal from Constitutional Court of Kosovo, we have proceeded the Medal of Merits for his contribution worldwide on the rule of law. So, and in terms of time, I don't know if I can even start. I know the guy there is very restricted when it comes to time. And I'm a constitutional scholar. So I think even my topic is related to the International Court of Justice. So I don't know why the organizer wanted to keep me in the room with the constitutional scholars, professors, judges. But the topic is related to the impact of the International Court of Justice advisory opinions, because as a Kosovo we have faced this impact, and there are a lot of scholars dealing with and working on this, that how far the impact of those advisory opinions can go. So I have decided to present two cases where they can maybe contribute a bit on changing let's say, the minds of some scholars who usually argue that the fact that they are not binding, they do not have any international impacts when it comes to the international relations. So reading about this, I wanted to bring the attention to the Chagos Archipelago, the case where there were being a lot of, let's say, other decisions by other courts that they are based on the case of the advisory opinion of the International Court of Justice. So from this case, it was the situation where then later on another court decided that based on the interpretation of the International Court of Justice, within the advisory opinion, they decided to change even the map of the United Nations regarding the Chagos Archipelago, and then they put that very different. And the second case, I'm not going to explain this anymore because of the time, is the Kosovo case. Even, as I said, we call this advisory opinions. There is a huge difference to a lot of states that they decided to recognize Kosovo after the advisory opinions, and they mentioned that on their verbal notes that one of the reasons they decided so on is that they want to be in a compliance with the interpretation of the International Court of Justice. So this can be seen as a guide for states that the advisory opinions are not, even though, as it was mentioned, and it's clear on the mission of the court that those are not legally binding, but in terms of the contribution to the international relations, they have been promoting a big impact. So this was, as I said, it's not related to the topic of the entire panel, but I don't know why the organizer put me on this panel. So thank you.
Thank you. Well, before I'll make some conclusion on each and every one's speech, but before doing that, I'll just give the floor to you. So whoever has a question, please raise the hand, and also try to address to whom are you posing the question. Yes.
Thank you. My name is Kari Kuusiniemi. I'm the president of the Supreme Administrative Court of Finland. And as we learned from my friend Axel Kämmerer's intervention, Finland does not have a constitutional court. But I took a note on Professor Granat's presentation and also Ombudsperson Miliuvienė's presentation concerning how can a state where the rule of law prevails resist aggression from outside, and how can it be done without then violating the rule of law? Obviously, I'm referring to cases of so-called pushbacks where Lithuania, Latvia, and Poland, and also to some extent Finland are now on stage. Thank you.
Yes, let's take all the questions. Please write it down, and then we'll answer.
Thank you very much for all your presentations. I'm Jose Casado from DR. I'm interested in learning a little bit more of your various experiences on the implementation of this constitutional identity doctrine from Germany, particularly if there's any case or regulation in any of your countries regulating indeed the application of international judgments, because well, there are many reasons, so I won't extend myself. So that's basically the question.
I'm Zakaria Boudahab from Morocco. Many years ago, our university hosted a gathering around this proposition, creation of international constitutional courts. It was from Tunisia in particular, and I think some countries took part of this gathering, such as Canada, Morocco, etc. Do you think this proposition is relevant in the current context? I know that sovereignty, etc., superposition of many levels of courts, but do you think, such as, for example, ICC, International Criminal Court, or others, tribunal, this creation or this proposition is relevant in the current context? Thank you very much.
Any other question? Any other questions so far? No. No, but we'll take another 5 to 7 minutes. Okay, so who would like to answer the first question?
I can try. Thank you very much. In fact, all the questions are worth to organize the separate panel. And I will try to answer the one concerning the resistance to constitution done by Constitutional Court in the sensitive cases. And in fact, we're in different position, Lithuania and Poland, and when the Polish Constitutional Court was destroyed and demolished, Lithuanian Constitutional Court still remains strong. However, the court, so first of all, the court should remain strong and independent, and it is the primary condition to have the result of respecting the constitutional values and to resisting all the attacks, all the aggressions from the external forces. Concerning the cases of migration, namely, the Constitutional Court of Lithuania had such a case and had to resolve it, taking into consideration the protection of fundamental values of the individuals and the interests of the state. And it was the difficult case to find the perfect balance, to do not leave the state without the defense, and to do not allow for the state and for the state institutions to violate the human rights. So the balance and the argumentation and the real implementation of the rule of law, encompassing the human rights, because the rule of law as such and the democracy does not exist without the human rights. So implementing the human rights in that context. Let's speak the other.
Very quickly, like in 2 minutes, again, the Kosovo example. We didn't have the experience of Poland, definitely, but our constitution has, and this is a good thing, has provided very strong constitutional guarantees. So it is practically and constitutionally impossible on part of the parliament to sort of get rid of the constitutional court in one way or another. They can do it, but there is only one way, if they can amend the constitution. But amending the constitution, I wouldn't say is mission impossible, but it is very, very difficult. It is, because at the end of the day, the proposed, and this is the good thing, that the proposed constitutional amendment, prior to be voted in the parliament, has to be reviewed by the Constitutional Court per se. So the chances to attack basically the Constitutional Court are slim, or practically zero. And I think this is a good thing. And so far I think the Constitutional Court, and I will conclude, has basically survived, if I could use this word, of any potential attempts in order to strip off the autonomy that it has currently. So this is the one example of the rigidity of the Kosovo constitution, which in fact served its purpose. Yeah.
Yes. I would just like to briefly address the second question, which was on the respect of international judgments and their implementation by the national constitutional courts. I think this depends very much on the rank of these of the conventions that these international judgments relate to, and in most countries, the European Convention of Human Rights, I think it's mostly about the European Convention of Human Rights, ranks below the Constitution, and the constitutional courts cannot pronounce itself on a violation of them. And even if there is a violation, for example, the Federal Constitutional Court said we must usually respect the judgments of the European Court of Human Rights, but since it is below the Constitution will, in a conflict, prevail over this judgment. And we have a similar phenomenon in other member states, the doctrine of contra limiti by the Italian Constitutional Court. And I should cite a court in which the Italian Constitutional Court said we cannot apply a judgment rendered by the International Court of Justice because it contradicts basic values of the Italian Constitution. And this is indeed a conflict of justice. Maybe a word on administrative courts. I think the administrative courts play a very important role where there's no constitutional court, but are not so easy to protect. In Germany, we had that law for the better resilience of the constitutional court. I think this is not so easy, although not unfeasible, but it's not so easy with the administrative courts. And last remark, in Austria, by the way, because Kelsen was mentioned, in Austria, I was told by an Austrian colleague that the powers of the constitutional courts are limited because the constitutional court should not be above the other courts. It should be on the same level with the administrative courts, or the constitution is superior to the other laws.
Well, I think in the interest of time, I'll just wrap it up with 2 or 3 more sentences. So in today's panel, we spoke about individual complaint. Why? Because constitutional courts serve as guarantor of constitution for the people. So the individual complaint is a mechanism that will give access to citizens to touch and be protected by the Constitution and feel it and feel protected by it. So it's a very important mechanism. A part of that, we spoke about the abstract constitutional review of laws, which is very important. However, the colleague from Romania spoke about omission. And sometimes this is a big area of debate, that when we speak about constitutional court and their legitimacy on doing so, we think about the fact that the judges of constitutional court are not elected. So having such big power over the laws is very important and should be carefully used and carefully exercised. So in that regard, we are not positive legislator, we are negative legislator. We just can say what is missing or if a law is unconstitutional, but we can not write laws because that power comes from the sovereign, only from the election, and it is reserved based on the Kelsen model, is reserved only to the legislative power. We spoke today also about having effective remedies. Sometimes the Constitutional Court, considered as court as guardians of Constitution, that seems that to have just a declaratory power. However, depending on the architecture and also the constitutional architecture of the countries, sometimes the court have more power. However, in doing so, we have to be careful of judicial activism, which is also something that we don't want to be accused of, because deference and withdrawal is also an element that should be guarded by Constitutional Court in order to leave the other courts playing their role in interpreting laws. So in this short overview, I'll try to wrap up everything that was said, and most importantly, there is no constitution without Constitutional Court or other courts that guarantee, that serve as guardian of Constitution. The case of Poland is an alarming one. When we thought that the rule of law, it was something that was granted, that was there, that was no questionability about that, then you see that, I mean, the power, the power and the politics, the way the politics fights the constitutionalism sometimes needs to be guarded. And without Constitutional Court, there is no other guards. So this is why it shows once again the importance of Constitutional Courts and courts in general that has this function of guarding the Constitution. Thank you very much. It was a very good panel. Thank you, everybody, and thank you for following.